Yes, call the matter. 230 matter.
230 mode habeas corpus. Praveen is.
So this is a fresh one. What do you say this?
Lord, now we have traced him. FIR is registered today
Against whom?
against the suspected accused, Lord, and is secured. We have just received the information. So therefore, if
He may be produced before this honorable court because he's still not in Bangalore.
okay, because Saunur police station is at a distance of about 8 hours travel by road. So that from here. So if he over the phone, if he communicates, probably we'll arrange for that.
The larger picture here is that, my lordship, the police inspector, respondent number 4, is involving himself in commercial disputes between parties, and he's organized kidnapping of the petitioner's husband herein and had him moved to Savnur. The moment this habeas corpus was filed, he's organized for his coordinates in Savnur to have the victim picked up from there, my lordship. This, my lordship, is a direct violation of the victim's rights, my lordship.
No, may not be beyond the scope, not because the FIR is registered today. He cannot say that there was a complaint before us. He only alleges that there was WhatsApp message sent. Why did we come to the police station and register complaint? Or, my lord, through the portal that he should have registered the complaint. That the registered complaint was registered, we have immediately acted upon and secured. Can't make allegations like that.
Petitioner, my lordship, is a pregnant woman. She goes to the police station at 4 o'clock telling that her husband has been kidnapped. They make her wait for 1 hour and they say it cannot be registered. In fact, the police inspector, respondent number 4, very clearly says, you have to pay the remaining money and he will be released. This is the way the state functionary is acting, my lordship, to recover the money of private parties. In fact, my lordship, even in January 2025, the respondent 4 summoned the petitioner's husband and under the duress of arrest made him pay 40 lakhs, my lordship. This is in respect of a civil dispute. If the state functionaries take it upon themselves to act as commercial courts and resolve civil disputes in police station, my lordship, the rights of the parties will be violated.
Lord, the averment in the petition is, my lord, the cause of action for all these submissions in January 2025. You would keep quiet. From what I see, my lord, paragraph 3. He has kept mum. And now he raises all these. January is the. He should have filed a complaint. Lord, January he says all these transpired. Should he not then, Lord, come before the authorities or before the police and register a complaint?
My lordship, it is the police who are harassing.
The police is also there according to him.
Police.
Respondent number 4.
Police is where, my lord? I'm sorry.
Respondent number 4 is involved in the
Paragraph,
kidnapping.
see paragraph,
Involved. Yes, we will take initiate action, appropriate action.
para 5 and para 6.
Yes. He says in collusion. My lord, if that be so, let him bring evidence and we will have to act, my lord. Now, the scope of this petition is that he is there. If somebody has kidnapped, we have secured.
You put it on record that.
Yes. No, for immediate satisfaction of the petitioner.
No, we'll record your submission.
Yes.
They say this petition has been listed in the post-lunch session on an urgent mentioning made by the counsel for the petitioner in the morning. This petition has been filed with the following prayers. Mr. Beliapa, SPP, accept notice. He states that an FIR has been registered
In crime number 120/2025.
2025.
Hosakote subdivision, my lord.
Just give the details.
Yes, I'll give the details.
Full stop. On the complaint made,
Lords,
the complaint made by whom?
by the wife of the,
On the complaint made
petitioner.
by the petitioner, he states that a status report shall be filed within 2 weeks. We notify on.
yes.
25-4.
Oblige, Manoj.
Do you know that matter? No? Passover matter. Good call.
Serial number 1, passed door matter.
Yes, please.
Lord. The order of this court, my lord, that he should be released forthwith. This order, my lord, is dated 27/3/25, my lord. It has reached the Central Prison, Bangalore on 28/3/25.
28.
28/3/25, my lord.
What happened on that day?
On that day, my lord, the jail authorities, my lord, they were about to release this detainee. The third respondent, my lord, they have apprehended and taken him to custody in the prison
His
itself.
third respondent.
My lord, the third respondent is the prosecuting authority in the previous case, who had arrested this accused. And my lord, in that case, the Honorable High Court has granted bail.
R3 then apprehended and produced him
Produce him before a special court.
before Sessions Court?
Yes,
Or
it
before
is a
five?
special court, my lord, before, my lord, initially it was before additional CJM Bangalore. Thereafter, my lord, it was produced before regular court, my lord, which is a special court. Initially, my lord, on 29, the 24/10, my lord, first production. Apprehension was on 23/10. Production was on 24/10. He was remanded to judicial custody time to time. Meanwhile, my lord, charge sheet was also filed. My lord, we challenged his arrest itself by filing a petition under 482. My lord, the 482 petition was allowed. My lord, in that petition, my lord, there was a contention of the state, my lord, that immediately after release, he should be detained in deportation center. That has been considered by the learned single judge. It was rejected. That relief was not granted. On the other hand, directed that he should be released forthwith from central prison. Well, the act of respondent number 3 in taking him to custody, at that time, my lord, there was no order of even 28/3, your lordship. 28/3 order, my lord, was passed subsequent to arrest, your lordship. The act of third respondent in taking him to custody in the prison itself is contrary to the order passed by this court. And to arrest him, my lord, there shall be an authority, either order or under any provision of law. The procedural compliance, my lord, is not there at all. He has been taken, my lord, then, my lord, produced before the Assistant Commissioner of R3. He issues a letter. Since this accused has been already taken to custody in central prison today, we are producing him in the same condition so that he should be detained in deportation center. This letter is the letter, my lord, which is contrary to the order passed by this court. My lord, in pursuance of this letter, my lord, R5 passes an order. My lord, mechanically, that letter, my lord, the order of this court was enclosed to that letter, 28/3 letter. The order of this court, my lord, passed by single judge was within the knowledge of R5 also. They ignore it. R3, R5, they ignore the order of this court. The mandate given by this court, my lord, has been flouted without any reason. Next, my lord, where he was taken, not known. He was not informed the grounds of arrest or why he was arrested, my lord, as required under Article 22(1) of the Constitution. My lord, this is again another violation. Then, my lord, that next day itself on 29th, my lord, Saturday, we filed this habeas corpus petition. Our writ petition shows, my lord, we were not knowing where he was taken, where he was detained, who has taken him. But the fact, my lord, that later, my lord, this petition was being called on Tuesday, that was on 2nd or 3rd, my lord.
Where is the present status?
Now, my lord, that as per the letter, my lord, is they have detained him in deportation center,
R5.
R5. My lord,
He is
Just
now
a,
at your
just a
center.
correction, my lord. Just a correction. Sorry, sir. My lord, it is not deportation center, it is restriction center.
He is now at restriction center.
He is at restriction center.
no,
Deportation center is who are waiting to be, who are overstaying and whom we have kept in the deportation center to deport.
But that is not a deportation because he has a criminal case.
That is why this is restriction center. We have restricted his movement. I'll point out that, my lord. I've called out in my objections with regard to.
please. My lord, in the order, my lord, 28(3), it has been clearly mentioned that he has been taken to deportation center till he is deported. This is the letter, your lordship, that dated, my lord, in the objection statement, my lord, reply letter.
But cannot be a case of deportation at this stage.
Yes, that is
Because
what, my lord,
because of the criminal case.
because of criminal case, my lord, rule 5(b), my lord, whenever a foreigner faces a criminal charge, he cannot be allowed to deport. My lord, he has to face the criminal charge. The order of this honorable court is also like that, that he shall face a criminal charge. For that he shall execute a bond of 2 sureties and undertake that he will continue to appear before the special
But
court
tell
for the
us
purpose
one
of
thing.
trial.
Because of a criminal charge, he can't be deported. His movements can be restricted.
Movements can be restricted, my lord, that has been explained by the Supreme Court only to the effect that his location where he is going to stay during this trial period has to be taken. And my lord, if required, my lord, any surety may be taken so that he should not jump away or abscond himself. Time to time, his movement can be surveillance by them. At best, my lord, to this extent. But physically detaining him, even in home, due apart restriction center is not permissible under law. My lord, an identical case, my lord, recently the Madras High Court Division Bench has considered. Similar case, your lordship.
Yes, sure.
Yes,
We will
please, Your
hear
Lordship.
that.
Madam, mark ಆಗಿದೆ.
Now, is it your case that bail bond, everything now becomes inconsequential?
Another 2 days there, my lord, to execute. He has to, my lord, 11th will be
No,
the
you
last.
are right. But today, what is the use of that bail bond being executed?
Yes, yes, my lord. All those orders are flouted, my lord. The direction of this court, my lord, passed in this order, my lord. Is
Oh, just show us that Madras High Court.
yes, your lordship. Sign karma. Karo jai.
Which paragraph of this?
Lord, kindly, here, Sri Lankan national, my lord, kindly paragraph 9, my lord, 8 and 9, your lordship, 9 onwards, my lord. And particularly paragraph 12, I take, your lordship. 9 onwards, my lord, they discuss an identical case where there was a bail order, bail condition was there. After release, my lord, he was detained in a restriction center. It's the division bench of Madras High Court, my lord, paragraph 12 and 13, my lord.
Yes, Mr. Pasha.
Please. Not here. Apart from this Madras High Court decision, my lord, particularly paragraph 22 and 23, my lord, it is very clear that in which case, my lord, bail order was passed. Thereafter, my lord, after release, he was taken to custody, detained in restriction center. That is also held to be without authority of law. This our case is also an identical case where, my lord, my submission is when they took this detainee to custody, there was no order of anyone. If the initial act is illegal, my lord, upon such an illegal act, if any order is passed, my lord, subsequently, all have to fall down because subsequent act also becomes illegal. My lord, this, my lord, the principle of doctrine of initial action, my lord, if it is, my lord, suffers from illegality, all subsequent act, my lord, has to fall down. My lord, this is, my lord, based on an authority of the Supreme Court. And actually, the single judge, my lord, released the accused on that ground only, because at the time when he was arrested by the prosecuting authority, he was not communicated the grounds of arrest. In Vihan Kumar's case, the Supreme Court has said that if the communication of arrest is not informed to the accused, his arrest becomes illegal. Here, second time arrest becomes illegal. Kindly paragraph, my lord, 108, your lordship. No, 107, my lord, kindly. Is settled legal proposition that if initial action is not in consonance with law, all subsequent and consequent proceedings would fall through for the reason that illegality strikes at the root of the order. In such a fact and situation, the legal maxim sub lato fundamento catio appus, meaning thereby that foundation being removed, structure or work falls, comes into play and applies on all scores in the present case. My lord, that in Badrinath case, the same principle was reiterated. Ultimately, in this case also, my lord, the entire order, my lord, it goes away because they had the knowledge. The arrest of this accused from central prison was without any basis, without any order. And it is contrary to the order passed by the learned single. It is not only, my lord, that they disregarded the order of this High Court, which is amounts to contempt. It is a deliberate act. It is not by bona fide mistake, your lordship. The language, my lord, yesterday we have filed, my lord, replay, in which, my lord, the translation of letter dated 28/3 in English, my lord, we have produced. In fact, your lordship, my lord, last date of hearing, to give the translation of the 28/3 letter is required. We have enclosed, my lord, to the reply. Kindly page 7, my lord. 7 is the letter, my lord, which is partially Kannada and partially English, your lordship. We have put at, my lord, page 9, your lordship, translation. My lord, this letter is spirit, my lord, is clearly that he has ignored the order of this court. What was not given by High Court, he has given it. He has occupied the position more than the High Court. Last paragraph, your lord. Required to be detained, he says, which was not given by this court.
How was he released from central prison?
He was not released at all. This officer gone inside the prison and he was taken.
What were the formalities followed?
Formalities followed, my lord, that as per this honorable court order, my lord, he shall be, as soon as the order reaches, he shall be forthwith released. My lord, they have released before that order could be given effect to. These officers were there. We were repeatedly following.
But tell us, Mr. Pasha,
Please, your lord.
strictly speaking,
Yes.
he should have come as a free person outside the prison.
Yes.
Okay,
That's
your interpretation.
that's all.
When he comes out of prison, he can be taken
But
by,
in this,
by respondent number 3. The difference.
Yes.
The best scenario is
yes, ma'am.
he should have come out, walked out.
Yes,
Possibly they can
they have
take him,
taken.
present him before 5. That's the only difference.
My lord, here, your lordship, that there was no such order of the honorable court to take him even, my lord, and produce. What is the order, my lord, passed by the single judge is that they have to inform the FRRO to take steps, not physically to take the accused. That order was not given. Kindly paragraph 9, my lord. To the registration officer, not to take him and produce before the court, before the registration officer. Again, my lord, that when he has been freed, seizing his liberty is not given to them. That amounts to taking his personal liberty. Not restriction also, not even a minute, my lord, even surveillance is, my lord, prohibited. I have relayed the decision of, my lord, Supreme Court where it is, even, my lord, pin hook on Google map itself is illegal, even against a foreigner. I have produced, my lordship, the decision it is.
What will they do if the gentleman escapes? He vanishes.
He cannot go back to his country, but fact is he can remain, he should remain in India.
But no,
My lord, this is, my lord, this is the concern of that court, my lord. My lord, this is the concern of the court which has passed the order. It has
No.
imposed the
Yeah.
condition.
Just 1 minute.
Please.
He is released. R3 has no role. Or they
Yes.
will only ensure
He has to appear before court
he
and
has to
execute
appear
bond.
before. So to that extent, they will accompany him to R5. They have to accompany him to R5.
They cannot, my lord, that is what
Okay,
it is.
okay. Let's ask you, how will R3 comply with this direction? Let's see that order of the
It is
High
not for R3, my lord, it is for the jail authorities it is. It is
Very
for
well.
the
Let's see
jail
that.
authorities.
Let's see that.
Yes, sir. Third respondent, my lord, is directed to release. Kindly,
It says it is also made clear that under section 3(2) of the Foreigners Act, if the competent authority feels by measures by means of imposing restriction, it is open to the respondents to move the registration officer appointed R3 of the foreigners rules.
yes. It is for them to move. Thereupon, my lord, the foreigner restriction authority has to pass an order calling upon this accused by issuing a notice, give an opportunity, hold an inquiry, whether he is such a person likely to abscond, likely to cause any act which is dangerous to the society. These are all subject to satisfaction, has to be made by R5 before passing an order of restriction of his movement. Without inquiry,
Okay, let's hear him.
without
Hear him.
inquiry, my lord, they pass an order, my lord.
We got it.
Lord.
Who will argue? Yes, Mr.
I'll only clarify one submission that was made, that he was still inside the jail and he was apprehended there. My lord, it's a matter of record that the direction was by the court to the jail superintendent to enlarge him on bail. It is on record that he was enlarged on bail, and thereafter he was secured and immediately produced before the competent authorities.
Secured where?
Outside, it is a matter of record that the superintendent has released him on bail.
How do we get that?
The registry, the register shows. We will produce that, my lord. Roman 5 of the 6 of the condition.
Their own letter, your lordship. Sorry.
Even our letter of request should state so. Even our letter of
See, we have an English translation given
Yes.
by him. You have that English translation?
No.
Just give it to him, Mr. Pasha.
Yesterday's replaced.
I think the Kannada version is clear, if my lord.
You read Kannada version.
You read
Kannada version. ಆದ್ದರಿಂದ, I am reading the last paragraph.
Yeah.
ಆದ್ದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಈ ದಿನ ಕೇಂದ್ರ ಕಾರ್ಯಾಗೃಹದಿಂದ ಬಿಡುಗಡೆಗೊಂಡಿರುವ released.
No issue.
No
Let's
issue.
read further.
That of course, my lord, I have expressed, my lord, regrets, and it is a
Who has
bona
been
fide
released-
belief.
Who has been released
Yes,
is taken into custody.
Taken into custody, yes.
and required to be present.
Yes. My lord, what the Supreme Court says is, my lord, may I read one paragraph of the direction, general direction issued, my lord? General direction issued. Could your lordship kindly turn to 10-1, the last page, my lord? Lordship gets last paragraph, 10-1. While granting bail to a foreigner within the meaning of the Act, the court concerned shall issue direction to the state or prosecuting agency, as the case may be, to immediately communicate the order granting bail to the registration officer concerned appointed under Rule 3 of the rules, who, in turn, shall communicate the order to all authorities concerned, including the civil authorities. If such information is furnished, it will enable the authorities under the Act, the rules, and the order to take appropriate steps in accordance with law. This direction was not forthcoming in the order, though there is a general direction. And, my lord,
No,
This-
as the case, immediately communicate the grant.
yes, therefore, Registrar Generals.
To the registration officer, that is 5.
My lord, read the subsequent paragraph. No? A copy of this order shall be forwarded to the Registrar Generals of all the High Courts. Therefore, this direction should have been there, even otherwise, by the High Court, saying that that order should be communicated to the competent authority, that's the registration officer.
Huh.
That which is not found part of the order enlarging in bail.
But in any case, how will that help the case?
To say that somebody has to inform the competent authority that this man is
But they
being
should be
privy to all these, yes,
all these happening
all
because
these happening. Yes,
he'll come under their jurisdiction.
yes. So therefore, even the rules or the act mandate that even a citizen, let alone the police officers, intimate about an illegal immigrant found anywhere. So therefore, under the bona fide mistake, my lord, of interpreting paragraph 9, we would just secure him. There is no arrest. Take him into our custody and inform as otherwise we could have registered another crime saying that under the act and taken him. That which is not done. Now under the act, my lord, there are not kindly see another thing he has pointed out now. It is not based on our request, my lord. It was based on the earlier request such an order is passed. Kindly see the impugned order, my lord.
Show us
Kindly see.
3/3/25.
Yes, order dated passed by them, impugned now. With reference to the request letter, Police Inspector CCB Police Station Bangalore dated 3/3/2025. It is much earlier to the order of this court granting bail. So therefore, the impugned order cannot be found fault with. The fault lies with the police officer to the extent of securing him after release is without authority. So therefore, it is not on our request.
No, but tell us one thing.
Yes, bro.
Was this order communicated to you? Then it should have been pointed out.
Principles of natural justice is what.
This order should have been communicated to the learned judge now who passed the bail order.
No, he was not party to that.
He was not a party to that. This must be, it was sent to you also.
No, it is based on our request, of course, but earlier to the bail order being granted. ಇದು objection ಆಗ್ತಿದೆಯಾ?
Now, just see this, just two. You know, it addressed to Warden Foreign Restriction Center. Taluk complied with the guidelines enumerated in the judgment in this dated this of this court between Babul Khan and the state of Karnataka and High Court of Karnataka, Bengaluru in criminal petition number this, police. So even this order, bail order was to be complied with. According to you, it has been complied with.
Not necessary. Not necessary.
According to you, it has been complied with.
Yes, Lord.
He was released from prison, then only you took over.
Yes, the compliance they are talking about is the compliance after 2 weeks before the jurisdictional magistrate to offer surety and get enlarged. By which time, my lord, that man will disappear is the apprehension. So bona fide belief and in compliance with the order of the court enlarging him in bail, interpreting paragraph 9, there could be a bona fide mistake as otherwise.
But tell us, Mr. Bhushan,
Please.
now tell us also, Mr. Beliappa, when you took over him, was this order already passed by them?
Order was not passed.
By them?
No.
When did they pass? When did you pass?
28.
28.
No, 28 means.
27 was the order.
When was he released from prison?
27 was the order.
No, when was he released from prison?
7 p.m. my lord. 7 p.m. my lord.
On
28/3.
The next day,
Subsequently, this order, sir.
Oh,
the direction goes to the superintendent. The next day is released. On the same day, we produce him. There is no illegal detention as such.
My lord, paragraph 5.1, your lordship may kindly see. Paragraph in the impugned order, my lord. 5.1, my lord. This was their prayer. That was rejected. That relief was not granted. 5.1, my lord, their prayer is, he is an illegal immigrant. He should be detained in deportation center. That was the prayer. This Frank Vittus case was also relied. Now relied by learned SPP, my lord. That decision was also placed before the single judge. By following the guidelines in that decision, my lord, the order was passed. Paragraph 5.1. Then the court shall specifically order to keep such persons in detention cells unless the competent authority has passed any order under section 3(2)(a) to F of Foreigners Act. This is the stand of respondent in that petition also. That was not granted.
No, it is on the sole ground that the arrest is vitiated because grounds of detention were not passed. That's the only ground on which he was enlarged and bail.
when did you pass the order at what time?
Lord, time is not forthcoming, my lord. To be fair to the court, time is not forthcoming, my lord. 28/3. It says it's 28/3, my lord.
No, but was he presented?
Please, my lord.
He was
I will make
presented.
my submissions, my lord.
Yes, what he
Please,
said.
please, if your lordship, my lord, at the cost of repetition of the bail order, my lord, dated 27 March 2025 by the learned single judge, my lord, if your lordship may kindly come to para 9. It is open for the respondents to move the registration officer appointed under Rule 3 of the Foreigners Rules. Point number 1. It is also made clear that under Section 3(2) of the Foreigners Act, if the competent authority feels that by means of imposing restrictions on the movement of the petitioner by taking bond or without surety, with or without surety, or in the alternative of to the enforcement of any of the prescribed or other specific restrictions or conditions, so as to observe or control the movement of the petitioner, such order may be passed by the competent authority with intimation to the concerned court. With intimation to the concerned court means, Lord, I'll come to that. The learned so and so says Bangalore City to conclude the special trials within 4 months. Now, if your lordship may kindly see. If your lordship may kindly come to my objections, which is filed today morning, para 7, page 2. I just read out 5 paras of my objections, my lord. Lordship got it, my lord. Page 2 of para 7. Please, my lord. The petitioner so and so, a Nigerian national holder of passport bearing number so and so, valid till 26/5/2020, wide annexure R1, arrived to India on 4/9/2015 on entry visa. Its entry visa is given for a conference, my lord. Visa expired on 8/9/2015. He has overstayed in country from 9/9/2015 to 26/8/2020 and currently staying illegally in India since 27/5/2020. On expiry of his passport, he has approached the High Court of Karnataka seeking direction to the respondent to produce the petitioner before the Honorable Court and to release him from illegal detention forthwith in the interest of justice. The petitioner was produced by the police inspector on 28 police inspector CCB so and so on 28/3/2025 upon his release from the central prison for issuance of restriction order under 32 under section 32E of the Foreigners Act with a request on so and so. The petitioner was the petitioner is housed in a foreign restriction center for male so and so, wide annexure R3 as per para 10 of the judgment dated 27/3/2025 of the Karnataka High Court in criminal petition number so and so, titled so and so. In this regard, the communication about the movement restriction of the petitioner in FRC was sent to the Ministry of External Affairs by the office wide letter so and so, dated 1/4/2025, annexure R4. My lord, it is intimated to their consulate also, wide annexure R4. My lord, it's at page 17. Please, my lord. The para 10, my lord, the petitioner movement restriction was done as per the power vested in FRRO Bangalore in pursuance of the MHA Government of India notification wide so and so, wide annexure R5 under clause E subsection 2 of subsection 3 of the Foreigners Act 1946 under para 11(2) of the Foreigners Order.
Was there any other conviction also, other cases also?
There's other case.
The history.
There's other case in Bombay.
Oh, there is another.
I'll come to that. The next para is that since his arrival in the country, the petitioner has overstayed in India from 9/9/2015 to 26/8/2020 and currently illegally staying in India since 27/5/2020. He has never approached any FRRO for registration of his presence in India. He is an habitual offender and is found engaged in drug peddling in multiple occasions. He is charge sheeted under various sections pertaining to narcotics, drugs peddling activities twice. First by anti-narcotic cell, Worli, Mumbai in crime number so and so. Second by narcotic drug squad, CCB Bangalore in crime number so and so. He has violated the bail condition prescribed by the Honorable 42nd Additional Citizen.
So are you saying from 2015 is continuing in
He is
India?
continuing. Therefore, Lord, the next page, my lord, the next page. During the bail, he was found engaged in similar activities. My lord, he was on bail in the Bombay crime. He was found engaged in similar activities by the Bangalore police. The petitioner is a foreign with suspicious background. His further involvement in the same act cannot be ruled out unless a close watch is maintained on him. As contended of para 2 of annexure R3 is concerned, the motive and intention of the civil authorities is well laid out as there is very likelihood that they may disappear and indulge in undesirable activities if not kept in the close watch. Para 13, my lord, it is further stated that in respect of the foreign national against whom one or more cases are pending, it is humbly submitted apprised that as per section 5(2)(b) of the Foreigners Order 1948, leave shall be refused to foreign national if the civil authorities is satisfied that the foreigner's presence is required in India to answer a criminal charge. Under 5(2)(b) of the Foreigners Order 1948, visa extension or grant were granted for such purpose, but this practice has been suspended. Since they all continue to stay, I'll take your lordships to the next paragraph, my lord, that is para 15. It is, my lord, it is submitted that provisions of the Foreigners Act 1946 cast the burden upon the foreign national only to prove that he is not a contravention of any provisions of the Foreigners Act 1946 by showing a valid travel document to the authorities, in absence of which he is illegal migrant, or proceedings under section 14 of the Foreigners Act can be initiated against such foreign national. This office frequently come across many of the foreign nationals who forge their passport and visa, as well as to the hoodwink the concerned authorities. In the instant case, the foreigner name is changed. His original name as per the passport is so and so, while he is known as so and so as per the FIR filed by the Bangalore police and Mumbai police as per section 54B of the Foreigners Act 1946. A name is deemed to be changed if the spelling thereof is altered. So my lord, this, especially this petitioner who is indulged in all these things, if your lordship, I take your lordships to para 22, page 8, para 22. Lord, I've said that, my lord, the petitioner is an the petitioner is an illegal migrant as of now, repeatedly involved in narcotic related offense. His repatriation is delayed solely on the ongoing criminal proceedings. He must be housed in the restriction center to prevent the disappearance of the disappearance and ensure deportation post trial. Lord, I've called out, my lord, the detention center is established under the authority of the central government for the purpose of the detaining illegal migrant, especially those awaiting deportation or pending repatriation order and who are not facing any criminal activities or active judicial proceedings. In contrast, a restriction center is a regional restriction office. My lord, that apart, my lord, para 24 is most important. My lord, the reason is this, my lord. The petitioner, despite being released from judicial custody, cannot be allowed to roam freely due to ongoing criminal trials. The first part, post violation of the bail conditions, my lord, post violation of the bail condition is also with regard to the bail condition which was granted to him in the Mumbai. Third one, my lord, lack of valid visa as on date he does not, and my lord, he doesn't, and established conduct of indulging in narcotics and trafficking, and more than that, my lord, as on date he does not have a valid passport. So, if your lordship could see now, probably the order is passed on 28.3. If your lordship may kindly turn to our order, my lord, at page 15, annexure R3. With reference to my lord, the order is 28.3. With reference to the request letter of the police inspector so and so, dated 3/3/2025, we would have acted late. It is 3/3/25. It is not on dated 28/3/25 we have acted upon. We have passed the order on 28.3, but the order is with reference to 3/3/25. I foreign FRRO in persons of MHA Government of India notification so and so hereby impose the following restrictions under E subclause 2 of section 3 of the Foreigners Act under 11.2. If your lordship may kindly see 11.2 of the Foreigners Order, my lord. Before that, my lord, I will take your lordships to order 5. Madam, Foreigners Order. If your lordship may kindly turn to page 15, annexure R3, this is an order passed, and it is referred to my lord, and it is addressed to the Warden Foreign Restriction Center, the Police Inspector CCB, so and so. The next page, my lord. for the kind information of so and so. The last one, my lord, it is intimated to the concerned court. It is not that it is not intimated. We have sent it to the concerned court. Therefore, my lord, at this stage, my lord, seeking quashing of our order, my lord, may not serve. It cannot be. The reason is, ma'am, we have followed all the procedures. Irrespective of, probably, my lord, your lordship may feel that 28th was the date when the request was made by the police, and we have passed the order. Perfectly right, my lord, but it was not on that request. It was the request made on 3/3/2025, and my lord, we have complied. No, my lord, he was released. He was released on by
3/3 when you received this letter
Please, my lord.
from Police Inspector CCP.
Please, my lord.
Was he inside?
Yes, he was in custody.
He was in custody.
For an offense booked under section.
Not on.
Does the bail order records both?
Yes, yes. Lord, all these contents in Lord was put for the
No,
learners.
it doesn't say so, no, Mr. Kaliappa, it only says NDPS. See page 13. See, there was no requirement, once he was under the Foreigners Act, there was no requirement for the court to say to present him under, to enable them to pass an order under 3. It was only NDPS, released for NDPS offense, with a further observation 3.
If your lordship may kindly turn to the order, my
One
lord.
submission,
If your
correction,
lordship,
my lord.
oh, sir,
Page-
if your lordship may
page-
kindly
page
turn to the
31, my
order,
lord. 14
order of the
of-
learned single judge, order of the learned single judge, page 2. My lord, this criminal petition is filed under 482 CRPC 528 BNSS, praying to set aside the order of arrest on 23/10/2024 and order remand on, so my lord, from 24/10/2024. 24/10/2024 is in custody. 24/10/2024.
So that means he was on custody.
He was in custody.
Charge sheet, my lord, for offence under Foreigners Act also. Kindly see, my lord, page 31. Court has taken cognizance for 14 also. Page 31 of petition, my lord.
Lord,
So initially FIR, my lord, for NDPS offence, but after investigation, my lord, charge sheet is filed even invoking section 14 of Foreigners Act.
my lord, may I
Yes,
make one
anything else,
submission.
Mr. Pasha?
Please, your lordship. My lord, here my submission, my lord. The detainee, my lord.
Have you filed rejoinder to what he has said?
Yes, my lord, for his, my lord, I could not file because copy is served today.
See, you have seen those
Yes, I will
paragraphs.
rebut, my lord, all those, but the question, your lordship.
No,
I
you
will-
want to file any rejoinder?
Yes, yes. I have to file.
What he has filed? See,
My lord, what he has filed, my lord, actually, your lordship, may kindly, I will file the reply for it, but before that, my lord, kindly, my lord, he was arrested in Mumbai, my lord, for an offence of NDPS, released on bail on 5/5/2018. My lord, his passport visa was taken to custody. It is still in the,
then you must put it in rejoinder, Mr.
yes,
Pasha.
yes, yes. My lord. That custody, my lord, that and.
Rejoinder.
And Lashima kindly here, Lord, he was continued to be in Mumbai facing trial of that case. He never involved, my lord, for 7 years in any case. My lord, my lord, his cousin sister who had come from Africa to take medical aid, my lord, on 15th of October, my lord, her operation was there in the hospital. He had come all the way from Mumbai to Bangalore, stayed in one of the lodges. On 18th, my lord, this accused was taken to custody from the lords, detained for 5 days, shown, my lord, as arrested on 23/10, my lord, planted this NDPS case and committed to custody. This is, we have awarded before the single judge petition, our petition
You
itself.
want to file rejoinder, yes or no?
My lord.
They have made, they
My lord,
have said-
allegations, your lordship, that allegations made, my lord, we will rebut, but the fact, my lord, at this initial step, my lord, their act is illegal.
Today, no, 1 minute, please. We will look into that. Today, according to Mr. Bhushan, in terms of that order which they have passed, he is in that restriction center.
My lord, even that order cannot be passed, my lord, because of the Supreme Court order, my lord, that is
That we will
supposed to
look into
preventive
it.
detention. There is
That
no
we
law
will-
for it.
That we will look into it.
Please,
His submission is based on what he has filed in the counter affidavit.
file, my lord, a
He
reply.
says, for these reasons, we have taken this action.
Yes.
So you
My
want to
lord,
file rejoinder?
I will file rejoinder, my lord.
File.
That apart, my lord, that apart with respect to senior counsel. My lord, now, for an argument's sake, my lord, if this petition is allowed, if this petition comes to be allowed, it's straight away violation of section 14. Because as on day, so 14B, my lord, it says, does any act in violation of the condition of the valid visa issued to him for his stay in India? My lord, it's straight away, again, it's a continuance offense.
It necessarily follows that. Very well. Let him file a rejoinder.
Please, my lord, please, my lord.
Just say that Mr. Pasha, a senior counsel appearing for the petitioner, states that he has received the objection filed by the
Respondent
objection
number 5.
statement filed by the respondent number 5. Respondent number 5. The same be filed within how much time, Mr. Pasha?
Lord, on 15th, your lordship, that.
On or before, by 15, he's be filed on, when will you, 15?
15th, your lordship.
States he shall file the same by 15. First of re-notify on. So when do you want?
15th minutes, sir. Maybe called on 16th, my lord, because we'll file it on 15th. It may
We
be
don't
called on
know.
16th.
We were just telling court may have a difficulty. We can have it on 16th.
Obliged.
So this court may have a difficulty. 16th. Okay,
Yes.
next. Next.
Cell number 20, she's BL
Yes.
But my application for early hearing in this matter, I had mentioned this morning, my lord, in that there has been a direction from the single judge to the BBMP to hand over the civic amenity site to me being the lessee of the civic amenity site in the year 2001. Till date, I have not been able to enjoy the property to set up a Kannada medium school. There is an order directly in favor of BBMP.
What are your instructions?
My lord, my senior not feeling well. My lord, please for time, my lord.
I had indicated in the morning, my lord, the matter was actually dismissed, filed in February 23, dismissed for non-prosecution in May 23, recalled in June, notice in October, and till date, no action has been taken. Even my contempt has been dismissed, my lord. And there's just another 6 years left of the lease. My lord, if my lord looks at the matter for
Now, the urgency is what?
I need
To run a school?
to run a school, my lord. I am running, I'm as of now, my lord, there are, the children, about 100 children that were.
When will he come?
My lord, next week, my lord.
Just say that the counsel for the respondent number 1 has filed an application for early hearing. According to him, the directions of the learner single judge has not been followed. Full stop. On the other hand, learner counsel for the appellant seeks an adjournment on the ground that the counsel, who is the counsel?
Sanjeev.
BL Sanjeev, my lord.
Sanjeev BL is indisposed. When do you want?
Lord, 15th, my lord, if,
The request, so as requested, comma, be listed on 16th.
Lord, 16th, if my lord may, otherwise
We'll give you
15th or
16th.
20th. My lord,
We'll give you 16th.
my lord,
What is the difficulty?
Lord, I'm not in, I'm in Delhi on 16th, my lord. May I request for the 21st, or 15th, 15th? Grateful, grateful.
Next, ma'am, just call the next matter.
32, Sirama 32.
Yes,
Please, my lord, petitioner is a stopgap employee in postal department. My lord. He is engaged in on,
is there any urgency?
my lord, because my lord is, even though there is a stay order, my lord, they relieved him from the service. My lord.
There is a stay order.
That is, if not relieved, not to relieve, that is the stay order, my lord.
To,
If not relieved, not to relieve.
so you are relieved or not?
Relieved, my lord, because before communication of this,
And then we need to hear the petition.
Please,
What-
my lord.
What was your status?
my lord,
What was your status?
I am a stopgap employee in postal department. my lord.
Stopgap for what purpose?
That is, I am appointed to the person who went on leave, my lord.
So he has come back.
No, my lord, my service is from 2018 to 2023, my lord. It is continuously, I am
It's a
engaged.
stopgap. Whosoever,
Please, my lord, with artificial break of 1 or 2 days in every 3 months, my lord.
but this is only when someone goes on leave, you are given engagement.
Please, my lord, but at the in particular place, my lord.
I don't know what is the right.
My lord, because my lord, I am under a legitimate expectation and equitable.
No, we don't
stock
want to
and-
know what is the right.
My lord, because my lord, the authorities, the rule says maximum 90 days or minimum 90 days or maximum 180 days, my lord. So my service is up to 15 years, my lord. So they are engaging, my lord. At one point of time, they use the authorities use the rule as shield for their purpose. Now they are against me as a sword, my lord. The same rule, my lord, because they are not obtaining the higher. Suppose if more than 90 days, it requires higher authority permission, my lord. They are not doing like that, my lord. Only our artificial, my lord. On record, there is a break, my lord, but on duty, there is no break, my lord. I am continuously working, my lord. I am producing, even I am handling the finance.
The tribunal say.
My lord, tribunal quoted your stopgap employee.
That's right.
My lord, recent judgment of the Supreme Court in Jaggu case, my lord.
Which one?
Jaggu,
Juggo.
No, Jaggu case.
That is
That
that's
it
in a
is
different
clearly, my lord,
context.
how the stopgap employees, they are, authorities are
That's
sucking.
not like a case of this nature.
My lord, same, my
The
lord.
casual labor.
No, my lord, here they also, they termed as a temporary employee.
Tell us one thing, why should you be engaged? Why not others also?
My lord, if they relieved me on completion of the 90 days or 180 days,
We'll hear you later.
please, my lord, kindly. Pleadings are over, my lord. They have filed the objection, the authority advocate. Kindly have it in this month, my lord.
What is the year of the petition?
2023.
We'll have it in June. Okay,
At the end of this month,
not possible. The board doesn't permit. Just say that re-notify, give it
or
in June.
first week of the June.
We'll give you first week. Just give it. Second, give it second, if not much.
26, 26, sir.
2nd June, first working day.
26,
Please, please.
36,
Which was this number, no? Call up.
number 36. Shri Ramchandra,
Yes.
Enter the appellant in this matter, my lord.
You appear for the appellant,
Please, my lord.
say none for the respondents. Adjourn to.
27. For 40.
Yeah,
Case pertaining to the absorption of the Millard respondent number 3 with giving Millard the seniority from the date of deputation. Millard, third respondent was in the cadre of Millard health officer in the Health and Family Welfare Department. Millard came to be deputed in the Elstvale Dental College on 4/2/2005.
4-2.
4/2/2005.
Hmm.
My lord, subsequently, my lord, both of them, my lord, the appellant is a, my lord, directly recruited, my lord, the assistant professor. My lord,
on
both
where?
were, my lord, applied for the post in a direct recruitment. My lord, third respondent was not selected, but appellant was selected and appointed in the year 2008. In the year 2008, my lord, on 19/5/2008. Subsequently, my lord, she was third respondent was observed into services in the year 2010. My lord, learned single judge merely because the third respondent has educational qualification to hold the post on deputation. My lord, given the retrospective seniority to her. I have question in the one, the writ appeal number 644. My lord, I have questioned the, my lord, the order of absorptions, which in the initially it was not treated as in public interest. Subsequently, corrigendum was issued. My lord, I have questioned before the learned single judge. In the two sets of, my lord, the deputation, my lord, other persons, my lord, they have not, the learned single judge has not given the seniority. But in so far as my appellant's concerned department is concerned, my lord, given the seniority, that is the issues in the 3 writ appeals, my lord.
Hmm.
And the, my lord, existing employees, my lord, the learned single judge interpret includes a person on deputation. My lord, she was in the Health and Family Welfare Department, not selected to the post, observed on her request by making an option. She is, my lord, treated as senior to her by the order of the learned single judge.
Yes.
That is the core issue, my lord. Now, my lord, the professor's post, my lord, now being filled up by the from the other department, excluding both of us.
How long this would take? This would take time.
Yes.
Well, it will take some time, my lord. It will take some time because it will take an half an hour, my lord.
Just say this, re-notify on.
But my lord, one submission, my lord. Your lordship may, my lord, direct the government, my lord, not to fill up the post of professor in, my lord, oral surgery because it will be filled up by a third person.
Who appears for the?
There's already a status quo order, my lord.
Status quo is there for, my lord, for seniority, but they're considering to the cadre of professors to be filled up, my lord, by other persons.
Just tell us one thing.
Please,
The dispute is inter se between two persons.
please, my lord,
Okay?
Please.
That issue need to be decided.
please.
Now, because they are considering making a promotion to the post of,
Post of professor in, for professor, my lord, which is in the oral surgery, my lord, that has been to be filled up by a person from the different department, who is junior to us.
but no, but you would be a contender for that post.
Please, my lord, we are also,
If our
we, both
seniority
of us
is,
also,
if
yes, my
our
lord.
seniority is decided, my lord, we will be the contenders for that.
But both of us are also, my lord,
What
belongs
they are
to
trying
scheduled
to
caste.
do, what they are trying to do is to put somebody from the other department to be posted as professor.
Other than you, there is no one in the department.
In our department, nobody is there, my lord.
The department has to work now. How will they work? You are in the interstate dispute. So who would decide then? Who would run the department? He will be senior or you will be senior, need to be decided.
Yes.
Depending upon of the department. You tell us who will work, you both will work. But issue, see, you have to see the practical aspect of it.
But my lord, that post cannot be filled up by, because we are eligible in the year 2012 itself, my lord.
Since when the post is vacant?
2017 or 18, my lord.
We are in 25, post has not been filled.
But it is a backlog post, my lord. It has to be filled up by only from the my lord, scheduled caste and tribal tribe, and both of us are belong to scheduled caste.
It's right. See, a post which is vacant from 2017 till date has not been regularly filled. They want to bring someone to ensure it, at least the working is on. We'd say nothing, we don't know, subject to what they say.
But he is junior to us, my lord.
Who?
That person who is claiming now, he is junior to us.
Who is the person who is claiming?
Shiv Kumar, one Shiv Kumar.
Since, has his request been acceded to?
No, it is in the process, my lord.
What is the process undertaken? Tell us.
Right, it is, my lord, file has now sent to the chief minister, now the DPC will take place, my lord.
When will the DPC take place?
The date has not been fixed.
See, it's everything
The
is realm
process-
of speculation.
So one person has filed a contempt stating that, my lord, the backlog post has not been filled up. Taking advantage of the division bench judgment, contempt is filed by some other person, and they sought to fill up this post.
To take instructions, are you fill? Is that post of professor?
Yes.
The post of professor in oral surgery, my lord.
Head of the department.
Head of the department in oral surgery. The person claiming is a different department,
What is the specialization?
forensic department.
What is the specialization?
Oral surgery, ma'am. Oral surgery.
The other, Mr. Bhagwat, what is the specialization of the other person who intends to
For
come in?
forensic.
Other person
Forensic.
is different discipline.
Very well.
Different discipline, not oral surgery.
Okay, we got
Person who
it.
comes to blood, the post of professor is a different discipline. He belongs to different discipline,
Okay.
not oral surgery. Not oral
Do you
surgery.
need to fill up? And this is, according to them, he is from a different field.
Yes, blood. Different discipline. Different discipline.
Yes. Just say that re-notify on, the counsel for the respondent state shall take instruction whether the post of professor,
Professor.
Professor in oral surgery. Oral surgery.
professor in oral medicine,
Oral surgery.
oral surgery.
Oral surgery. Oh, yes.
Oral surgery is sought to be filled from a person outside the discipline.
Yes, blood.
Re-notify on June.
Till then, my lord, may say something.
Mr. Bhagwat,
Yes, my lord.
Mr. Bhagwat, the post is vacant from 2017 till now. 8 years have gone by. No appointment made. Do you expect in a 1 month time they'll make an appointment? Let's see.
I cannot say. I cannot say. I cannot say.
Next.
Entry model, whatever is that, may be continued.
Status quo order is there.
Is there
Yes.
now?
That will be continued, my lord.
Acha, interim order, if anyone just check up.
Yes, my lord, it is that.
Interim order, if I need to continue, just there. Last order is there. Interim order, if I need to continue.
41.
The matter is pending in Supreme Court also, no?
Please, ma'am.
Yes,
My lord, it is
re-notify.
coming up on 22nd.
Yeah, re-notify.
Please, ma'am, obliged.
87. 43.
Yes, Mr. Amresh, what is this?
Appearing for the respondent.
Oh, Okay, this is that scale.
Fixation of, my lord, pay scale.
Lordship,
How
Apex.
long you would take, both of you?
I take 30 minutes, not sir.
30 minutes? What about you, Mr.?
Lord, it lies on a very narrow compass, my lord. If my lords were to see one paragraph, my lord, in that,
Show us.
the seventh pay commission report, my lord. Which specifically dealt with the fixation of the pay scale. Page. It starts from 163, my lord. We have only given the extract of this, my lord, relevant extract. Page 163, my lord. My lords have. It has been submitted that due to the classification of DGs into apex scale and HAG plus scale, several difficulties have arisen in the states, resulting in several petitions in the courts and the tribunal. Further, it has been brought out that the post 6 CPC, the post of Director General of Police as a head of police force, was given a higher pay scale, the apex scale 80,000 rupees. With rest of the DGs were given the lower pay scale, HAG 75,500 to 80,000. Quite often the selection to the post of HOPF is not done on the basis of seniority, and HOPF are sometimes transferred out without adhering to the 2 years tenure rule. Situation has arisen when an apex scale DGP is removed to a post, kindly mark this, my lord, to a post carrying the inferior HAG scale, and his pay scale is reduced from apex to HAG. It has been demanded, therefore, that the HAG scale may be
What is
abolished.
the present position? How much a DGP is given?
Lord, DGP is given, my lord, this 75,800.
That's the HAG,
HAG,
not 80,000.
no.
That's the higher scale,
Yes, that is the apex scale, my lord,
apex scale.
apex scale. Now kindly see the next paragraph, my lord. This is, my lord, the situation has been resolved, my lord, by recommendation. This commission feels that the abolition of HAG scale will disturb the traditional relatives to the armed forces, police forces, and CAPS. Hence, it is recommended to retain the HAG in IPS, and in case of transfer of HOPEF to some of the other posts, her pay may be protected. Even though a person is transferred, my lord, to
From
a
80 or from the higher scale to the lower scale.
lower scale, he is protected. Lord, it is exactly the same. In terms of this recommendation, my lord, I said I was appointed, my lord, by the UPSC as IG, and due to the challenge made by one of my junior, my lord, before the CAT, and my appointment was set aside, and I challenged this before this honorable court. There was an interim order, and matter went to Supreme Court, and Supreme Court remanded the matter, but there was an interim order, my lord, in the process. My lord, I went on leave, my lord, during this process. My lord, when I go on earned leave, I carry the pay scale drawn on the day on which I go on a leave, and I retire, my lord, on the day, my lord, on attaining the superannuation. My pay scale was the same which I was carrying, my lord, when I was on earned leave.
On the strength of that interim order.
No, not on the strength of the interim order. My lord, the rule itself says, when I go on a earned leave, I carry the pay scale during that.
Oh, so you went on earned leave.
I went on earned leave, and I retired, my lord, during the period of earned leave.
During
So the
that
last pay drawn would be, my lord, the pay scale of IG. And apart from that, my lord, this also clarifies of a stay of the order passed by the CAT and this honorable court. And finally, Supreme Court, my lord, held, because the petitioner therein and, my lord, the person who has challenged my appointment, both have attained the age of superannuation. Their lordship felt, my lord, I will read the portion of the order. It has become academical. There is no use of such thing. But they record a finding that the so-called allegation made in the NHRC report, they do not indicate, my lord, the petitioner. That is, my lord, the respondent herein. Therefore, they find that, my lord, the credence given to the NHRC report, my lord, is not correct. Therefore, my lord, the appointment made to the post of DG, my lord, and IG, my lord, is not disturbed in the sense. That is another facet of our contention. The CAT said, my lord, I am entitled for it. And they have also examined whether two persons were holding the, when I was on leave, my lord, the person who has challenged my appointment has assumed the charge, but he was not selected. He assumed the charge of DGP. Then they asked, my lord, whether he was drawing the pay scale of apex scale. Then, my lord, the state government filed an affidavit saying, no, he was not drawing the apex scale. I was the only person.
So what you are saying is.
There was no
two persons who are
Yes.
holding that scale.
My lord, that
You are the only person who was.
I was the only person during that period.
So two person cannot have the benefit.
Yes.
We will hear you. How long you will take, Mr.
30 minutes, madam. Because straight away I can take your lordship to page 40 of.
We will hear it. We'll have it after vacation.
Yes, yes.
Just say re-notify in June, May.
Question is, even after transfer and retirement from the DG and DGP post, a pay scale of 80,000 rupees and his pension should be raised on the basis of that. That is the moot question.
Okay.
Once he has been transferred and handed over the charge to the incumbent, then he is not, no,
Say, are you saying?
that is
you are
only the
saying-
moot question.
You are saying that he's going on earned leave,
Yes, that will
not
not,
on the apex scale.
that.
That's your case.
Yes, yes. We have granted him leave not on the DGP and IGP post. We have granted him leave on the post of the chairman. of the-
Transferred post.
Transferred post. That is what the Ministry
We'll
of
hear it.
clarified.
We'll see the reasoning of the tribunal also.
In fact, we have prepared written brief. Shall I hand it over?
Give
The,
it to him, exchange, you have the note.
they also had.
Lord, we have prepared, my lord. It requires some changes.
Very well. Just exchange yourself and just give it in June.
Right.
Thank you. Any other matter? That matter.
9/6.
Any date, my lord?
Yeah, fixing a date. we'll-
9/6.
9/6.
45, serial number 45.
Lord, I appeal for the appellant, my lord, in writ appeal number 80 of 2024.
You are part of the same batch?
Yes.
Okay, what is, acha, okay, you are not there, very well. We thought that Mr. Who was to, Mr.
Few of
Nagaland
the
was starting.
petitioners had to continue, my lord. Mr. Datar, I believe, had to continue, and senior advocate Mr. Sondi was also appearing in that matter.
I think there are about 3 of them on that side.
Yeah, complete.
They are about
So
4
you have to complete?
Yes,
Okay.
Please.
What is your case?
Lord,
Sorry, before sending letter, Mr. Sondi, my lord, some inconvenience today. I'll let the others finish.
There are others also.
Let the
We will
others
not
finish.
take- Who else have to argue for the appellants? See, we have only one request. Whosoever is arguing, we have to give you a brief note of just give a note of submissions, appeal number, and who is what are they. So that at least we can keep a record.
Lord,
Yes.
Lord, the issue before the court now is that, my lord, whether, my lord, the authority could have gone for, my lord, the review of, my lord, the final key answers. My lord, the learned single judge, my lord, has said that once the authority has concluded that these are the final key answers, the authority has no power to go for the review of the final key answers. Otherwise, there is no end to it, is what the reasoning, my lord.
Yes.
Yes. And now, my lord, the constitutional courts, my lord, have always, my lord, helped the candidates when there is patent error. If the error is writ large on the face of the record, my lord, the courts have always rescued, my lord, the candidates. My lord, in the instant case, my lord, the candidates, my lord, are not seeking, my lord, the relief from, my lord, the court to, my lord, look into these questions. All that they are saying, my lord, is that the authority itself has taken a conscious decision
my lord, to go for, my lord, review of final key answers because of the reason that many candidates could not submit their objections to the provisional key answers.
Answer keys.
As a result, my lord, the inbox was full. And hence, my lord, once, my lord, that final key answers were published, my lord, they filed objections.
What were your objections?
My lord, my objections, my lord, were, my lord, series of objections saying that.
Many.
How many, my lord? 5, my lord, I understand.
Where are those?
My lord, in respect, my lord, of that particular.
Which are the question numbers?
Question numbers, my lord, in respect of 15,
Sir,
91.
in which appeal number?
80. Lord, I do not have a copy of the representation that I have given, my lord.
Why not? You should have.
I will, my lord. I will definitely provide
just
you
to
as part of,
clarify,
my lord, the writ petition.
just to clarify, I have summarized the objections raised by each of them in my note of contentions.
Including his.
Every single appellant,
Objections were there?
not
The objections common to others?
not one single objection in respect of the disputed questions. I have summarized in the table and I have said not one appellant has raised it. I have put it on record.
Ma'am, I will, my lord. I will. My lord. Right now, my lord, I do not have a copy. My lord, in this case, my lord, now, my lord, the second committee has found, my lord, that there are 3 questions which needs to be addressed, which, my lord, may please take my lord, writ appeal memo, my lord, which I have pointed out. My lord, at page number 10 of my appeal memo.
Your appeal number is?
80 of 2024. Appeal memo, page number in page 10, my lord. In a table, my lord, I have given, my lord, in respect of 5 posts. In page 10. My lord, table I have given. Second time, my lord, what they have gone into. In case of, my lord, the first one, assistant engineer electrical, my lord, to which this case is concerned. My lord, number of question answer key changed 1. Number of incorrect question grace marks awarded 2. So only in respect of 3, my lord, have examined question number, my lord, 35, 76 and 79, my lord, expert committee reports. Lord, section, the question number 35. Question number 35, my lord, pertains to, my lord, that missing R. My lord, since, my lord, the input R is not there, my lord, the question itself becomes wrong.
Which are your additional 2 questions?
2 questions, my lord, 76 and 79, with in respect of, my lord, Arctic.
They are also part of the original.
Yes, Arctic.
Which are the additional 2? You said 5. They say 3.
Yes.
Which are those additional 2?
May I point out? (15) and 91 in B2, my lord. B2 version. B2 version. My lord, the question paper.
Is the question paper?
Yes. There, my lord, 15 and 91, my lord, is.
They correspond to all these 3?
No, my lord, that is separate. That's what I'm saying. Apart from these 3 that I am pointing out, 2 questions which I raised, my lord, was 1591, my lord, which are do not correspond to.
Their answer on that? On 15 and the other one, what is their stand?
My lord, may I?
This was initial. This is your objection to the initial answer key.
Yes, correct. Subsequently, my lord, that was the pass. And now, in respect of this, my lord, 76, in respect of, my lord, Arctic, my lord, the second review committee found that all the answers are correct, and accordingly, grace marks was awarded. And my lord, in respect, my lords are the President, my lord, under Article 111 of the Constitution.
See, we may have to stop here today.
Please.
We'll continue. Huh? Just give it a.
Next week.
Do it in June only now.
Week, my lord.
We are really clogged.
26th
heavy,
is a-
man.
26th is a
Not
working
many-
Saturday. If it-
Huh?
26th is a working Saturday if it only convenient to your lordship.
26, not possible. Checked up. Just give a date, ma'am, whatever convenient.
If it is part heard, my lord, would be grateful. Otherwise, my lord, if bench changes again, everyone has.
We
to-
have heard 4 councils or 5 councils. How many councils we have heard? Obviously, we have said, so our order sheet is clear.
6,
Just re-notify all.
6.
Next, okay, thank you.
ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಇದೆ 79 ಬೇಕಾಗಿದೆ. ತಗೊಂಡ್ ಎಲ್ಲ